Across to that, just setting up the pretext on the hijab debate, what happened with the Karnataka High Court order and the split verdict coming in from the two-judge bench of the Honorable Supreme Court between Justice Dhulia and Justice Gupta. Two separate points of view, and that's why the matter will now be going to the Chief Justice, who will then opine on this, and we'd see where this goes further. That's the question. And of course, this is also about the rights versus rules. So let's try and understand what happened. The Karnataka High Court order said that the Holy Quran does not mandate wearing of the hijab as an intrinsic part of the religious practice. But the split verdict in court, where one judge upholds the notings of the observations of the Karnataka ban and appeal is dismissed. On the other, the judge is in favor of removing this entire ban, or perhaps the order of the Karnataka High Court. Wearing it may have to do with culture. It's not religion. It's a cultural practice, not an essential religious practice. One judge says wearing hijab a matter of belief/expression. On the other hand, when the court said that midterm, the petitioners miserably failed to prove it was essential. In fact, the petitioners changed the narrative in the Supreme Court. From saying it's an essential practice, they said it's integral. That's what they did to the practice of Islam as a culture. Now, one judge turns around and says wearing hijab should be only a matter of choice. Again, Karnataka High Court order says issue blown out of proportion. Middle of the term, the judge, one of the judges says that the move is to deny education because of hijab. So the issue is about no girl or no child should be denied education. Unseen hands at work to engineer disharmony. And here the judge says removing hijab is attack on privacy and on dignity. So that's the observations that have come in. We have with us this evening Pinky Anand, former ASG, and also Aryama Sundaram, very senior advocate. So two very, very astute legal minds with us. So let's go straight across to them to get their points of view. My namaste to both our guests. First to Aryama Sundaram ji. Aryama ji, where would you stand here? Are you a little surprised on the split verdict? And should this be a rights versus rules debate as it has now become?
Look, this issue itself is a very debatable issue. There can always be two views to it. And the fact that there were two different views from two different judges only shows you the robust sense in which the judiciary works, where the bench of two judges are willing to differ with each other with the views on the subject differs, which actually is a very positive sign that it's not as though if the judges just think exactly the same and decide exactly the same, and because one judge says something, the other judge says so. In fact, this is a very healthy practice, and I've always said very often that the dissenting voice of today becomes the law of tomorrow. You never know. But having come to that, let's understand why this dissent has occurred, according to me, in this judgment. The Karnataka High Court went entirely on the basis of whether it's an essential religious practice or not. Came to the conclusion it's not an essential religious practice, and therefore the government was within its rights to ban it. The Supreme Court, one of the judges, concurred with the Karnataka view and said the issue was one of whether it's a essential religious practice or not. It not being an essential religious practice, the ban cannot be faulted. The other judge, however, said that this does not appear to be merely a religious practice. It is a cultural practice where the tests are different. Is it long in point of time? Has it been prevalent for some time? Is it bona fide? And is it part of the culture? And then brought in Articles 19(1)A, which deal with the freedom of expression, brought in Article 14, which has to do with your right against discrimination, brought in Article 21, and then said, this is something which cannot be banned unless on one of the grounds which you find for banning it under the specified articles, under 19(1)A or otherwise. And since none of those grounds are made out, it was not a ground for banning. Having said that, let's understand one simple thing which arises in this case. The simple thing is this. If a school, for example, says, look here, I believe that you cannot, this is my school uniform. You want to study in my school, you have to wear this uniform. Now that happens in a lot of schools, even in the South, where the girls are usually used to wearing their long skirts and their half saris, as they were called. There are schools, convent schools, insist on the girls wearing a skirt. Now, a girl cannot say, I refuse to wear a skirt, and therefore, but the school should change its rule and its uniform. So that is not the issue. The point here is that the state got involved in it. If it was just a school saying this is our uniform, you abide by the uniform or don't join the school. Nobody can then turn around and say, no, I insist that the uniform should be something different. But unfortunately, this is a case where the state got involved. And once the state got involved, the fundamental rights came into play. And those fundamental rights are something which need not boil down to religion, as Justice Julia said, but could be governed by other fundamental rights. And therein is the point of difference between the two judges. One going only on the basis of whether it's a religious tenet, the other judge going on the basis of other fundamental rights like freedom of expression and otherwise. And I think that's where the dissent is.
But the state has the rights, Pinky ji. The states had the rights to govern, decide what would be worn in its schools, and the school at that point. But the crux of the matter, the court should understand that in this school there were 96 Muslim girls. Only 6 of them suddenly start the agitation. Till all these years they were following the rule, and the limitation of not wearing the hijab was only restricted to the classroom, not to the entire campus. So did that escape the attention of the courts? And if the courts and if the judge were to say, this dissenting judge or the judge who had a different opinion saying that this ban should be done away with and it's a matter of choice, then aren't you opening a Pandora's box? Then anybody and everybody will say it's a cultural practice. How come they never took the same position with parda or with girl-child marriage? At that time you are going against orthodoxy, a social evil, what is something which you're supposed to talking about liberalism, opening up. And now suddenly you are becoming an advocate of orthodoxy if it's a matter of choice. Pinky ji, where do you stand?
No, agreed. I think, Anand, that you kind of hit the nail on the head with this discussion and leading the way forward. The ultimate situation is, to what extent can a student govern his own rights where it is involved in an institution and in a particular forum? To what extent can you challenge an age-old practice which you yourself have confirmed? To what extent can you challenge rules that are made for perpetuation of a situation of education? To what extent can you dictate what kind of dress should or should not be decided? Ultimately, we are all bound by certain rules in each of our procedures. So even, for example, we as councils are engaged by a code of conduct of the kind of clothes that you are required to wear. There are parameters. So when there are parameters which are set out and which is set for all universally, and as you rightly pointed out, in the classrooms and not in the entire campus also, and there are various practices that could be practiced on the ground of orthodoxy, then for the interest of education, for the sake of institutions, for the sake of having regularity and uniformity, I think there is some essential practices that might and would be allowed by a state. And that is what the state has done. Aryama Sundaram himself has said, ultimately if it's a private institution, it doesn't matter, it's a different matter. But if it's a state institution, then no, it's a question of freedom of conscience. I'm afraid these questions don't arise, and each of the fundamental rights that we have are subject to public order, are subject to certain constraints. They are not unrestricted fundamental rights that we have in any part. And there should be a valid ground for some exercise that is done. So, for example, if these are the grounds that we are considering, and also possibly the nature of non-essential part of the practice also, which is a question mark area, as one of the judges has taken up, then the question of what is the difficulty? You've done it for several years. You are being constrained to the extent of having regularity in school uniform and in the manner in which you can have. Why should some people be allowed to change the code of conduct on the ground of freedom of expression, if you like, which is one of the grounds that has been raised? I'm afraid it is not an absolute right. None of these rights are absolute. For the sake of any other fundamental right. Education itself is a fundamental right.
Yes.
Institutional education is another fundamental right. So you're talking about balancing of rights. The question of raising it to the level of some kind of chaos is something I think that does require to be questioned. And it is very heartening to note the judgment which ultimately deals with the fact that an institution has a right to decide the manner in which education will be imparted